headphones here, but it doesn't seem like they're very loud. How do we switch them up? Come back through. Audio. Control panel settings.
Just key in audio.
For some reason we haven't dialed in, so I'm hoping the sound works. Hello? She said something that we need to do when it, and I couldn't hear her. Hello? I need some help. We usually do it with the phone.
So why can't we dial in?
Because apparently it's coming through on these.
It might be the there's a camera picking it up there. Might have
Yeah.
a microphone on there.
Yeah. It's back over now. Doesn't help with this the arm that I had.
Right, 12:30, we've got 43 attendees so far. People will drip feed in. Should we start? Are we ready?
Good to go.
Hi, good afternoon everyone and welcome to today's webinar. We are going to be covering employment tribunals and High Court enforcement. And I have with me here today Monica Beckles from Inside Advantage. She is an employment specialist covering HR and advocacy. And I have Jonas with me, who is Business Development Officer here at the Sheriff's Office. Very welcome to you two both.
Thank you.
First, can I ask you all to type into the box that you are able to hear us and see the screen in front of you with our presentation? Wonderful. I'm getting lots of people saying yes. Brilliant. So first of all, I'm going to go through a short disclaimer. Please treat the contents of this webinar as food for thought, but don't take any action based on its contents unless you have taken legal advice. The speakers today cannot accept responsibility for any errors or inaccuracies, loss or damage, unless we have given you personally specific advice relating to a matter about which you have given us full background details. You must also bear in mind that the contents of this webinar are based on English law, and because it contains archival material, that material is bound to go out of date. Now, the webinar today is covering two parts. We've got the first part covering employment tribunals and employment law, and the second part by Jonas delivering enforcement of tribunal awards. So, without further ado, I'd like to hand over to Monica.
Thank you, Sarah. Good afternoon. Pleasure to be with you today. As Sarah touched on, my name is Monica Beckles, and I'm going to be talking you through some elements of employment law that are fundamental to employment tribunals, and then discuss the process that you would go through if you received a claim through a tribunal. So you'll see on the screen what we're going to be covering. So we'll be talking about employment status, how they affect employment rights, and then more about tribunal claims, time limits, when can somebody bring a claim, what do they need to have, what criteria, eligibility, all of that, and then some of the processes that happen when relationships start to break down and what's open to employers to do. So let's get going on the first slide. What the first and most important thing to think about when in any employment relationship, and specifically when you receive an employment tribunal claim, is it from an employee or is it from a worker? Because that's actually going to determine what they can claim in a tribunal or a court. So on the screen you will see the definition from the Employment Rights Act 96 of what an employee actually is. That's under section 231. And it's an individual who has entered into or worked under, or where the employment has terminated or ceased, worked under a contract of employment. This area of law can be quite blurred because the definitions between an employee and a worker can be quite similar. So if you look at section 233, a worker is defined as what I've just read out to you under 231. So a worker can also be an employee, or they can be defined as a worker. And that applies in 233B, where it says any other contract, whether express or implied. Essentially, you can have a worker who sits next to an employee, does very similar work to them, but the dynamics of the relationship are slightly different, and therefore the rights of that individual are different. And if you go a little bit further down in that definition, you will see where it says the individual undertakes to do or perform personally any work or services for another party to the contract whose status is not by the virtue of the contract that of a client or customer. If it is a client or customer, you're moving into the self-employed arena. So the first thing to think about in any situation of a dispute is this with an employee or is this with a worker? So if we now move on to the next slide, I'll give you a little bit more information here about how to tell the difference, because as we've just seen, the definition can be quite blurred. So an individual is likely to be a worker and not an employee if most of the following apply. There are tests in law that will be examined if a dispute about whether an individual is an employee or worker arises. And these are three key elements of the test. The first part there is you will see mutuality of obligation. With a worker, there isn't any mutuality. That means the business does not have to offer them work and the individual does not have to accept the work. They work when they want, and that should be without penalty. And I've put a case there that those who like to do that, which I find very useful because you can read the full judgment and really understand the dynamics of that particular case, is the Carmichael and another v. National Power. And that will help you understand the mutuality of obligation and why it's important in situations like this. The next thing if we look at is control, and that essentially looks at what control does the employer or the business have over the individual that's working for them. And this was a real fundamental aspect of the Uber cases that you've probably all heard about over recent times, because although Uber tried to say the individual was self-employed, they exercised an element of control that moved them into the worker status. And again, that's a useful case to have a look at if you have an opportunity. The next element is personal service, and they must be required to perform the work personally and cannot send a substitute in their place. That, if they can send a substitute, sort of again moves you closer to the self-employed arena. Now there's a case that is very, very useful to look at, and I'm going to read it out to you, but this will be updated on the slide for you to look at when they're sent out. And it's Ready Mixed Concrete, in brackets South East Limited, v. Ministry of Pensions. It's a very old case, 1968, but it gives very clear guidance as to the tests that need to be examined to determine if somebody is a worker or an employee. And if none of the above apply, then the individual is likely to be self-employed. But as some of you may know, in recent times, there's been a lot of focus on employment status. And you had the Matthew Taylor report, and the government's put out a good work plan, and there's going to be legislation coming in where they're trying to sort of bridge that gap and make it more clear and align employment law with HMRC rules, because they can be similar, but there can be some differences, and it does confuse employers and businesses. So moving on from that, if you have a look at this slide, it gives you a snapshot of the rights that an individual as an employee would have over that of a worker. One thing to point out here is the top line, written contract. I'll put the tick in the worker box. As it stands, at this very moment, a worker does not need to have a contract, but from April, they will. So for me, let's start thinking about it now, and then it's easy to make sure that we get ourselves into the habit of producing the documentation that individuals should be getting. Previously, you didn't have to give a worker a contract, but as part of the, government's focus on employment status and improving worker rights, they've now set out that you must provide a contract or a statement of particulars to a worker. And then the other thing at the bottom, workers get, as you can see, national minimum wage, paid annual leave, rest breaks, and pension if they earn over the limit, which I think is around £10,000. Okay, moving on, we're now going to look at where a claim can arise and what sort of grounds individuals can have a reason to bring a claim in a tribunal. So the next slide talks about unfair dismissal claims and wrongful dismissal claims, and they're two of the big claims that you will see in a tribunal or a court. Unfair dismissal is when somebody has been dismissed by an organisation for a reason that they consider to be unfair, or in a manner that they consider to be unfair. I've added the unfair part to that. It's not actually in the legislation, but I think it's very, very important to consider it being unfair. Wrongful dismissal is a breach of contract. Now with that, that's essentially when you've terminated an individual in a way that is not set out in the contract of employment. So if the contract states a termination will take place in this way and notice will be given to the individual, if you do not comply with that, that could be wrongful dismissal. And irrespective of the length of service the individual has, they can take a claim to a tribunal or a county court. If the individual's on a high salary, they're likely to go to the court because there's a cap in a tribunal of £25,000. So high paid individuals will probably take a wrongful dismissal claim through the court. That's a damages cap in the tribunal. If we just have a look at the blue box, that sets out a definition from the Employment Rights Act as to when you can terminate an individual. So Section 92 has 4 areas: capability, conduct, redundancy, and a statutory duty or restriction. So they're the typical reasons that an individual would be terminated from their employment. Section 98(1) talks about some other substantial reason, which is a catch-all to say there could be a reason that you need to terminate an individual that does not fall within Section 98(2). An example of that would be something like you have an individual who has a toxic relationship with the rest of the employees in the business for whatever reason. They haven't committed misconduct, their performance is good, there isn't a redundancy situation, but it's affecting the business, it's affecting the smooth running of the business, and therefore you need to take action. If there is something like that, it's possible that you could terminate the individual under some other substantial reason. But as Sarah said from the outset of this, it's very important that you take advice on any individual case that you may have. So they are the reasons that an employer or business can terminate an individual's employment. Unfair dismissal also has another element to it, which is constructive dismissal. This is where the business has not terminated the individual, but the individual themselves has decided that the conduct of the employer leaves them with no alternative other than to terminate their employment immediately. It's typically due to a breach of trust and confidence or some act that the individual feels they just cannot continue to work for that employer. And again, I've put a case there that you can have a look at for information on background for a constructive unfair dismissal claim. Now, burden of proof in a constructive unfair dismissal claim, the employee must show that they resigned for a fundamental breach, as I said, some act that they believe they cannot continue to work for this employer any longer. And it must be a significant breach to damage the relationship of trust and confidence. And it's for the employer to then show that either didn't happen or the actions were fair, and they need to defend it in that way. Okay, now we're just going to have a look at some other types of claims. So we talked about the typical unfair and wrongful, but discrimination is a claim that the numbers are increasing in the tribunal. And essentially, it is treating a person or group of people differently, less well than other people who do not have a particular protected characteristic. We should all know the protected characteristics, but they're things like disability, age, race, sex, sexual orientation, gender, religion, marital status, pregnancy. There's a lot there. So there are a number of protected characteristics that if an individual has that, they cannot be treated differently because they have those characteristics. And if they do, they could bring a claim in an employment tribunal. In an employment tribunal, for a discrimination claim to unfold, the employee just needs to present facts that infer that discrimination occurred. The burden of proof then switches to the business to demonstrate that it wasn't because of the protected characteristic. So if something did happen, it could be totally justified, but it's for the business to demonstrate it wasn't because of that individual's protected characteristic. Okay, if we look at qualifying service and time limits now, employees have the right to claim unfair dismissal after 2 years continuous service. If you look down the bottom, there's a note. It's actually 1 year and 51 weeks because the statutory 1 week notice period will be added onto the length of service if they terminate at 1 year 51 to take them up to the 2 year limit. So it's very important that if there is any thoughts about terminating somebody, that you are aware that if you're coming up to that 1 year 51 weeks, be very, very careful because they could then have the requisite service to submit a claim. So if the dismissal is connected with any of those things in the middle of that slide, so health and safety, whistleblowing and everything else that's there, the 2 years doesn't apply and they can submit a claim from day one if something happens. And the wrongful dismissal claim that I touched on earlier, where that can be taken through the court, is also a day one claim because it's a breach of contract. Other day one employment claims are discrimination that we just touched on, ordinary maternity leave, unlawful deductions. So that's if I refer back to how I started this, looking at whether the person is an employee or a worker is important because some will not have the right to do this and some will. It's very, very important. If you look at time limits, claims must be received by the employment tribunal within 3 months of the date of termination or the last act the individual complained about. That's actually 3 months minus 1 day. And if it doesn't go then by that time, it may not proceed, although solicitors can actually make a request for it to be heard. And in discrimination claims, sometimes that is allowed in a tribunal. County court claims, however, the individual has 6 years to bring a claim. So depending on what avenue they choose, employers can't necessarily exhale after 3 months if something happens. So a claim could come in a bit later on, so beware of that. Okay, we're now just going to have a look at the procedure that happens when a claim is submitted. So an individual would submit a claim to an employment tribunal on a form called an ET1. The tribunal will log the claim and send a copy to ACAS and a copy to the employer. They may enclose an ET3, which is the form the employer must use to submit their response, or you can get that online. When you receive the claim, I think one of the first things you need to do is check the details carefully. What has the individual said the employer has done that they're bringing this claim for? Is it factual? Does the worker have the right to bring the claim? Are they an employee? Are they a worker? Is the claim in time? If you dismiss somebody 8 months ago and the claim comes through, is it out of time because they have 3 months, as I've said? So have a look at all of those things just to see if it's a claim that is likely to proceed in the court. Then gather all of the relevant information and documentation for you to defend that claim. And that would involve deciding who to include, who to involve in the response, if it was a dismissal, who did the investigation, who chaired the disciplinary, all of those things. You'll need to get all of that information together for you to put together a sufficient response to the ET1. You must respond on the ET3 form or the claim could be thrown out. So don't just put a letter together and send it to the tribunal. Get the correct form and complete that form. The form must be returned to the tribunal within 28 days of the date of the letter that accompanies it. And failure to do that could lead to a default judgment being entered against you. When you're completing your ET3, I would strongly suggest that you take advice on that, but in the event that you decide not to do that, it's very important not to just deny that this happened. You have to provide sufficient detail for the tribunal to understand the facts and what happened leading up to the claim. And that includes explaining what the business does, explaining what the role of the claimant is, and the key events that led up to it, and why you deny the claim or the parts of the claim that you do deny. If you're admitting some elements of the claim, it could be that they were terminated wrongfully and you recognise that you should have paid them notice. You might want to accept that part, but the parts that you do dispute, you have to give a very clear reason as to why you are doing that. One of the cases that I touched on earlier, it's the case with, actually I'll send that to you afterwards, but there's a case that we're going to refer you to that if you read that, it's very, very important because the claimant succeeded because the business just did a blanket denial and really didn't go into any level of detail as to why the claim should not succeed and what their version of events actually was. So it's very important not just to say, actually, no, this is wrong, this didn't happen. You have to spell out what did happen and why the claim is wrong. It's a good idea to check with the employment tribunal that they have received your ET3 once it's submitted because of the importance of the timescales. And once it has been submitted, you'll get an acknowledgement from the tribunal, and then you'll normally get some correspondence to set out how it's going to proceed. If it's a discrimination case, you'll often find there's preliminary hearings to be held beforehand before it can progress to a full hearing. There may be a case management discussion. It depends on the complexities of the case and the response from the employer. So the court will look at that and then determine how it needs to proceed. Some will go to full hearing, but often there is a preliminary or a case management discussion. If we move on to remedies now, and the options open to a tribunal in the event that they find a ruling of unfair dismissal from a claim from an individual, the options they have, which are set out in the Employment Rights Act section 111 to 132, are the individual can get their job back. That doesn't happen too often in my experience because once it's got to that point, the relationship has broken down. If it's a very large organisation and there's an opportunity for the individual to go into another division, it's possible. But typically, once the relationship has got to that point, reinstatement is not something that happens. So re-engagement, as I've said, a different role, that's something that could well happen, but reinstatement unlikely. And then there's compensation, including a basic award. You get a basic award, and then you get compensation. So it's designed to put you back in the position you would have been in if you hadn't been dismissed unfairly or had to resign because of something that the employer did. For other types of claims, tribunals will make an order just to, give you the salary if it's an unlawful deduction from wages, as an example. Depending on what it is, they'll just try to redress what's happened. But please be aware that judgments are not always given on the day of the hearing. That could follow afterwards. So in the event of a finding for unfair dismissal, as I've said, there's a basic award. The current limit at the moment is on the screen, and it's calculated in the way that you would if you were making a redundancy using multiples of a week's pay. And the maximum, as in a redundancy situation, is 20 years. And the age of the employee is relevant, again, as in a redundancy situation. There's also a compensatory element, and that is designed to make sure the employee or the individual has not suffered any losses as a result of the actions of the employer. And as it says there, it's calculated from the date of the hearing. But what's very important in this is that the claimant, from the date the employment is terminated, either by the employer or by themselves, they have to make efforts to reduce their losses. They have to be out there searching for alternative work and trying to, find a salary that means that the amount the employer will be awarded or made to pay will be reduced by anything that they get in the interim leading up to the tribunal case. And if the individual cannot prove that they have been actively looking for work and applying for jobs, it will affect the level of compensation that they're actually due to receive. Few things here to think about. We touched about the limits for compensatory and basic award. There is no limit on the compensation awarded in discrimination cases. They can be significant depending on the details of the case. In discrimination cases, you will also see an award for injury to feelings, and that's referred to as the Bento band, and it's from a case that's detailed there, Bento v. Chief Constable of West Yorkshire. And if the acts of the employer has caused the individual injury to their feelings, and it doesn't have to be a sustained sequence of events from an employer, it can be a one-off act. But if that causes an injury to the feelings of the individual, then the amount awarded, they could also get an injury to feelings award, which starts at £900 and ends at £44,000. There's three different bands, a lower, middle and a higher band, and it depends on where the tribunal sees the severity of the act and the injury caused to the individual's feelings, where they will do that. There are cases where it's just a one-off act and an individual has been awarded something that sits within the middle band, which is between 9 and 26,000. So it can be a substantive uplift if there has been injury to feelings caused by the actions of the employer. Furthermore, if you follow a disciplinary or grievance procedure but you do not comply with the ACAS Code of Practice in doing that, say you do not conduct a sufficient investigation to give you, just cause to go ahead with the disciplinary, or you don't give somebody the right of appeal, or you just don't follow that code of practice, it's possible that there could be an uplift in compensation by up to 25%. So it's very, very important if you're following a disciplinary or grievance procedure that you follow it and any code of practice by ACAS as closely as possible, and that ensures that the individual is afforded a fair process. Now, even where an employee is found to have acted unfairly, tribunals recognise that sometimes the actions of the employee could be key. So they can reduce the compensation if the dismissal was inevitable. So even if it was unfair, but it was inevitable, there could be a reduction, saying, this person would have been dismissed in any event if the employee had done it fairly. So the actions of the employee do come into play, and the tribunal do look at both sides and the circumstances of the case. And that goes back to why I said earlier, when you're completing the ET3, as much detail as possible will be helpful, because that will be referred to throughout the tribunal, throughout the hearing. And if you're bringing something up later on that isn't on the ET3, it could cause you some problems. So please take the time to do the ET3 properly. It really will set out the rest of the case. Now we're just going to have a look at some of the awards that have been given over the last year. This is up to March 2019. And as you can see, on here, we're just looking at unfair dismissal and discrimination. Discrimination broken down by the various characteristics. And you can see there are some sizable awards being given, particularly for unfair dismissal there, and disability discrimination and age discrimination. The median awards, now obviously if you look at the maximum awards, there's going to be certain cases that are going to skew the median awards and the average awards significantly, because if you look at those, they're actually more realistic to the typical awards that you will see. But just be aware, as I said earlier, dependent on the salary of the individual and the circumstances and everything else, you could find yourself getting up to a higher level of award. When an individual does submit a claim, or before an individual submits a claim, they have to go through contact ACAS, and there's an early conciliation process which occurs first. And typically, ACAS will try and liaise between the employer and the employee to see if they can resolve the case. The courts do, or the tribunals do, like to see if it can be resolved before it goes ahead. So this is something that's been put in place to see if that can happen, if a settlement can be agreed, and it can prevent the case from progressing to a full hearing. And as I've touched on earlier, the things that ACAS are very important: early conciliation, the codes of practice, and then if the claim goes underway, there is also arbitration as well, where the tribunal can make a decision on the case based on the evidence submitted by the parties, again, as an alternative to a full hearing, but it could still progress onto a full hearing if that doesn't work. And I just want to give you a snapshot now from this slide here, which shows you what's happened to the claims submitted to a tribunal over the last few years. Now, this starts in 2015, which was before the abolition of the fees, which occurred in 2017. Now, you can see nearly all of them are on an upward trajectory. There are more and more claims being submitted. You can see the percentage increase for all of them. And employers really need to be aware of this, because while the employment tribunal fees were unfair, now we're back to the situation where an individual can just give it a try and see what happens. So it's very, very important to ensure that you're in the position to defend it if that were to occur, and that you're aware of, the landscape of employment tribunal claims and everything that's happening at the moment. So if we look at the top line, unfair dismissal, you can see a huge spike in claims from 2016-17 up to now. That's grown significantly. And the other one that's growing quite a bit is disability discrimination, and that mirrors the size of the awards that we touched on earlier. But that just gives you a sort of a snapshot of what's actually happening out there in the tribunals. And then what I'd like to sort of wrap up with today is an overview of what has happened, because with employment law, it changes quickly. A case can change the way something has to be managed by an employer. So it is important to keep up to date with case law and what's happened. As the Uber case is a perfect example. Tinley Plumbers is a perfect example as well. They're things that have changed the way that businesses manage the models that they're operating on, because they thought it was fine until it went to a tribunal. So keep an eye on what's going on in the tribunal. It can really help you. But the snapshot of things that have come in, and the next slide will talk about things that are coming in, is in January of last year, mandatory reporting on CEO pay started. An important one here is itemised pay slips for varying hours worked. Now, I know a number of companies that I work with that hadn't actually started doing that when I started working with them, and that's very important. If an individual's hours vary, put the number of hours they're getting paid for on their pay slip. That may mean an alteration to your software or whatever, but that came in April. If you're not already doing that, you need to get that sorted out as soon as possible. They've increased the upper limit that can be awarded for aggravating features in a case. So again, another reason that you need to avoid doing anything that could aggravate an individual, because that just increases potentially the compensatory award that the individual might get. The consultation for the ethnicity pay gap reporting closed. We're awaiting the outcome of that. And there was the first Supreme Court ruling for decades on a post-termination restriction, and that's to do with the wording and how much a person can have interest in another company when they're employed. And a case there to look at is Tillman v. Egon Zender, and again that will be sent out to you with all the slides after the presentation. Looking at what's due to come in this year, the annual executive pay gap report is to be published. Some of you may have heard about a case about veganism being a philosophical belief and therefore potentially coming in as a protected characteristic, and there's been a bit of panic about this amongst employers. It doesn't mean that if somebody comes in and says, I'm a vegan, you now need to treat them as if they have a protected characteristic. This particular case, again, if you have a look at it, we'll send the information out. The individual was you know, his commitment to veganism was something I particularly hadn't, you know, seen before. Not just in, he didn't eat, use animal products, he didn't let anybody in his house with food that contained animal. I mean, he really took his veganism to a level that I've never come across, and that was why that judgment was made. So look at the facts of the case. It isn't a blanket, you know, thing that applies to all vegans. April, as I touched on earlier, workers are entitled to a statement of written particulars. And previously, employees could get a contract after 2 months' employment. Now it's a day one right. So a good idea would be send out an offer letter together with the contract of employment at the same time, and that makes sure that you comply with that right. Reference period for calculating a week's pay, which is used in a number of areas of employment law, has been extended from 12 to 52 weeks. And also, some of you may know, IR35 is extended to the private sector. It came in for the public sector 2 years ago and caused absolute chaos. It comes in for medium and large organisations, and essentially everything that we've spoken about at the start of this presentation, determining the employment status of an individual, is a crucial practice that a large employer or a medium-sized employer now has to go through, because if you don't do that, everything now falls on you. Before, you used to put a contract together that said the individual takes the liability if they're deemed to be an employee. Now it will fall on the employer. You need to know what status the individual is and tax them accordingly. So it's very, very important to understand employment status and what individuals should be under what status. Jack's Law is being introduced in April as well, and that's 2 weeks paid parental leave for the loss of a child. And then the Supreme Court is to rule on some of the cases that have been going through to do with worker status. So that's something to keep an eye out on. Not expecting it to change, but with employment law, you never know. And then just other things, ethnicity pay gap reporting, shared parental leave could be extended to grandparents. Restaurant tips, individuals are to receive their tips in full. The government are thinking about creating a duty for employers to give flexible working to all of their employees, because at the moment it's not really being embraced by employers and people are being denied the opportunity. So that's something the government are looking at. And then they're just having a look at general parental leave and pay policies. So finally, just something to think about to kind of make sure you don't, as much as possible, find yourself in the position that we're discussing there, and that's facing an employment tribunal. There are some practical steps there to look at and think about to prevent this where possible. And these are about, you know, standards of behaviour, setting them out very clearly. There's a case on here. If you see that case at the bottom, Capital Retail Finance Services, that was a discrimination case. Woodhouse was a manager. The two employees brought that case against the manager and the company, and the manager was made to pay compensation by the tribunal, but Capita were not. The reason? They had comprehensive policies in place, they communicated them, and they trained them out. So even though the individual did commit an act of discrimination, it was on his head, and the employer defended themselves sufficiently. So there's just some tips for you, to things that you need to think about internally to avoid, where possible, an employment tribunal claim. I hope that's been helpful. Thank you very much.
Thanks very much, Monica. And obviously we've seen some significant sums in some of those cases and discrimination.
Yeah, very.
So we're going to be covering the next side, which is enforcement. But quickly first, we're going to have a bit of a recap. And we're going to ask you guys some questions to consolidate your learning. So, first question should be appearing on your screens now, and that is, how many years must you have accrued as an employee to bring a claim for discrimination? Now, bit of a trick question there. There is no minimum, so that's a day one ability to bring a claim for that one. And yes, most of you got that one correct. And can I also remind you all that please do ask questions as we go through. we'll be taking hopefully some questions and answers at the end of the webinar. So don't forget, if you've got a question, pop it into the question box and we will endeavour to answer it. So next poll, how long does an employer have to return the ET3 form? And yes, the correct answer is 28 days. Okay, and there is no upper limit for discrimination awards. Is that true or false? Excellent. That is absolutely true. And the final question here is, tribunal remedies for unfair dismissal include reinstatement, re-engagement, and compensation, or all of the above? And yes, the answer is all of the above. Right, I'm just preparing to hand over to Jonas, who is going to be covering the next part of the webinar. So, Jonas, over to you.
Yes, hello, good afternoon, everybody. So I'm going to be covering the more focused on the actual enforcement aspect of it. So certainly some of the topics that I'll be covering today is, of course, after obtaining the employment tribunal or settlement, we'll be describing the transfer up process from the High Court, what other methods of recovery you might have available to yourself, as well as the costs involved for yourselves and as well for the defendant. Obviously, the types of enforcement for writs, and of course claims under controlled and executed goods. So, I'm going to focus on the employment tribunal aspect. But once you've received the employment tribunal award in your favour, there is usually a date that is set by which the defendant's got to pay by. If a payment for any reason hasn't been made, it is quite reasonable for you to try and make contact to try and see when the payment is going to be made by the respondent. If for any reasons they, however, haven't said anything, then typically we would advise we wait in a period of about 42 days. Again, if they are appealing the tribunal decision, they do have 42 days from the date of the award in which to do so. So what else can be claimed? So you have, of course, the standard awards and the costs that Monica explained, but you can also claim for the statutory 8% interest per annum. So this actually, I mean, if your award relates to, for instance, discrimination complaint, then an interest, which usually will be calculated daily, typically would start from about 14 days after the order in which the award was sent to the parties. For interest in all other types of employment tribunal, it typically begins to accrue after 42 days have passed. Now, if you have been, of course, through the process that have been outlined by Monica and you managed to obtain your employment tribunal award but still have not received any money, then the next steps that you would have to take is to look at your enforcement options. And, of course, one of them being the High Court enforcement route. Now, the other methods of recovery that you do have available to yourself is a request for information. This is typically handy for if you wanted to ascertain what sort of assets that they might have, funds, income, etc. Now, you are entitled to, of course, apply for this order in order to bring the respondent to court to answer your questions, as I said, in terms of what assets that they might have. Your other option, of course, would be to issue a third-party debt order, which in effect just orders a bank to withhold the funds in a certain bank account number from being released until the courts have sort of decided what to do in that favour. And of course, the third and final part of it is actual enforcement of it. So that typically would involve either instructing county court bailiffs or high court enforcement officers, with of course the latter having generally more powers to recover debts than the county court bailiffs. But like with anything, there's always pros and cons. So if you wanted to, for instance, request information, The advantage to that, as you can see from the table, is that you'll be able to understand what sort of assets that they might have. The disadvantage, of course, is that the property or the assets that they do have by itself may never really be sold. Similarly, a third-party debt order is fantastic if you wanted their bank account to be frozen, but the problem is as soon as the order comes through, or when they get, for instance, an inkling that their bank account might be frozen, a lot of defendants will typically transfer money out of the actual bank account, which unfortunately means that the third-party debt order fails. Now, the third option, which is generally seen as one of the most effective, is to actually instruct either county court bailiffs or high court enforcement to attend. If successful, it actually works out that there is no cost, simply because the upfront fee that you pay, be it the £121 or the £66 for high court enforcement, that is actually recovered from the defendant if successful. The disadvantage to it, of course, is that if the defendant is bankrupt or has no valuable assets, then unfortunately there'd be very little for us to seize to try and recover your debt. So what happens if payment isn't made? You've gone through all the processes, you've obtained your employment tribunal award, you're now ready to go ahead and enforce. So typically, what most people would do is they would contact a company such as ourselves. They would say, I've got an employment tribunal award, I want you to take it on. The first step that we would do after obtaining a high court writ is that we would send out a notice of enforcement to the defendant, and then we would allocate an enforcement officer to attend, with potentially a view of taking control of some of the goods that they might have and selling that on, or arranging a payment plans and so forth. Where assets are taken control of, they are usually sold at a public auction, and we typically aim to make sure that we at least cover a substantial portion of the debt. So the aim is, of course, is that we seize those assets, sell those at an auction, and that way we can recoup your costs as well as the fees that the defendant would pay for our enforcement fees. If, however, the High Court Enforcement Officer isn't able to recover the payment, then the only payment that you would have made is just the initial £66 fee, which is just for the writ of control itself. Now, most High Court Enforcement Officers don't actually make their money on the fees that they charge you. A lot of them make their money by the fees they charge the defendant if they are successful. So, from that perspective, they are certainly incentivized to pursue it as far as they legally can, of course. Now, the transfer up process is ultimately a very simple process. You've got an employment tribunal award. The next step is you would contact the High Court Enforcement Officers. Now, some people will, of course, want to do the transfer up process themselves, in which case they will need to either complete a Form N471 and submit that to the courts to get that transferred up, or an N471A for ACAS settlement. Most High Court enforcement companies will tend to offer their own transfer up service for free, so it's probably worthwhile investigating that as well. And as I previously mentioned, the only fixed cost that you would pay up front would be the writ fee, which is the £66 fee. Now on to the enforcement aspect of it. So ultimately, in this process, there are 4 stages that most of our enforcement officers will tend to go through. Now, you're going to see that there's quite a lot of costs that are mentioned, but it is important for me to highlight that those costs mentioned are actually levied to the defendant. They are not something that we would levy to yourself in most cases. So the first step that we're going to go through is the compliance stage. Now, this is the part where the enforcement officer has obtained the sealed High Court writ. The next step afterwards is that we send out a notice of enforcement. That notice, it's called a 7-day notice of enforcement. However, it is a little bit misleading in the sense that the way it's calculated means that we would have to actually allow 7 clear working days, which means that things like Sundays and bank holidays are ultimately excluded from that. Depending on the time of the year, that notice could stretch out to a period of about 12 days. So, but ultimately, the purpose of it is to give the defendant the opportunity to pay the debt, whilst our fees that they would have to pay to us are still relatively low. It is an amicable way to settle the matter. Now, where we send it to is we've got to send it to the address that we will be enforcing at, which must be relevant to the actual business or to the defendant themselves. And what I mean by that is usually we would ask for either a registered address or a trading address of the business that we're attending. Now, if the respondent pays in full, then perfect. You get all of the amount awarded. You get the statutory 8% interest. You get court fees, and you get the writ of the £66 writ fee. So in effect, it means that you actually haven't paid us anything to instruct us. Our fees, of course, will then be levied to the defendant, and our fees at that stage would simply be £75 plus VAT. Again, it is important that I just clarify that this is not something that we would charge to the claimant or to the instructing party. It is simply levied to the defendant. But let's assume that, for instance, they haven't paid. They've ignored the letter. So the next, we go to the enforcement stage 1. And this is where an enforcement officer physically attends the premises with a view, of course, if we can, to take control of goods. Now, there is a fixed fee that is charged at that, and that fee is £190 plus VAT, as well as a further 7.5% of the sums that we are aiming to recover over £1,000. So what that essentially means is that for the first 1,000, we cannot add the 7.5%, but for any sums over the initial 1,000, 7.5% is added. All costs, of course, as mentioned, are recovered from the respondent. Of course, again, when the enforcement officer attends, the respondent pays in full, then those are simply the costs that they would have to pay, plus the initial £75 plus VAT from the compliance fee stage. But again, we assume that the defendant is being a little bit tricky and they don't actually pay up. So on we go to stage 2. And this is more when we're going to talk about controlled goods agreement. Used to formerly be called walking possession agreements. Now, this is ultimately when the respondents will refuse to make payment or wants to enter into a payment plan. These payment plans are ultimately secured by goods which the defendant cannot, either directly or via a third party, cannot remove or dispose of those assets. The defendant, should they continue to make the payments, then great. That would all be no further escalation will take place. However, in that stage, there is a fee, a flat rate fee of £495 plus VAT that is added on top of the bill, in addition, of course, to the fees mentioned in the compliance stage and the stage 1 as well. But let's assume that, say, for instance, in this particular scenario, a defendant has entered into a payment plan and they've defaulted. They stopped paying. And despite our very best efforts, they've still refused to pay. Or we attended and we believed that some of the goods there might be at risk of being removed. At that point, we have the right to push this forward to what's called a sale or disposal stage. And this is the stage where we actually take control of those goods. We remove them usually off-site. And we send them across to an auctioneer for the auctioneer to sell at public auction. The cost of this is a flat rate fee of £525 plus VAT, as well as a further 7.5% over and above the initial £1,000 fee. Again, these removal costs are normally included in the sale stage fees. There are certain other costs that we could also add on, which is things like auctioneer fees, etc. Things that by law we can add. If, for instance, as well, for example, we might have expensive machinery, printing equipment, etc., that the cost of removing might be fairly substantial, and in which case we can apply to the courts to have those amounts added on, but it is quite unusual that we ever have to go through that stage. So what are the potentially other costs? Well, as you know, the initial fee that you would have to pay is the upfront cost of £66. There is no further fee for yourself to pay, unless, for example, after instructing a High Court enforcement company, you've made a deal with the defendant, and in which case it would be quite reasonable for us to charge you our fees that we've accrued up until that stage. Or, of course, should you continue to accept, for example, a payment. We understand, of course, that not all the time, sometimes defendants will just out of the blue send you money, and that doesn't necessarily make you liable for the High Court Enforcement Officer's fees right away. So what we would typically advise is that you would speak to them. They would usually give you guidance on what to do next. Oftentimes, at least from our perspective, we prefer to recover our fees from the defendant rather than from yourselves. So what are the conditions for the actual enforcement? So we can enforce any point of the day, Monday right through to Sunday, but of course that's got to exclude bank holidays and Christmas. We can also attend, usually between the hours of 6 a.m. and 9 p.m, unless of course there is for instance, like a nightclub that might open from 10 o'clock till 5 in the morning. Then at that stage we can attend during those hours, even though they are outside of the regulations. The enforcement officer also must gain entry via normal routes. So that unfortunately means we can no longer climb through windows, do anything of the weird and wonderful that we used to be able to do prior to 2014. In terms of forcing into entry, the enforcement officer does actually have the power to do that, and we can force entry on the first visit in order so that we can levy against goods that are found on the premises with a view, of course, to remove them, etc. Now, there are certain aspects in terms of when we cannot do that, and that is, of course, if the commercial unit is attached to residential. For instance, if it is a pub with a residential flat upstairs, fortunately, we would not be able to force entry unless we have permission from the courts to do so. If the, of course, respondent has agreed and entered into a controlled goods agreement, we can, of course, legally force entry should the defendant cease to make any payments or cease to communicate with us. The enforcement officer as well can attend the home of a director of a limited company if it is the registered address of the business, or if the business trades from that address. For instance, there's plenty of online companies that might trade from home. We can attend. That is a relevant address at that point. Now, of course, needless to say, we can't attend the premises of a third party unless we have permission from the courts to do so. One of the key examples, actually, that we had quite recently is we were instructed in an employment tribunal case where, unfortunately, it appeared that the company, while still active on Companies House, had ultimately ceased trading and had moved their goods to a third-party premises. It was actually a warehouse unit. In that instance, we had to attend court. We had to make an application for permission to attend a third-party premises. So these are, for instance, one of the examples that would fall under that. Also, enforcement officers, we cannot execute against the royal residence, and we cannot attend diplomatic premises either. There are, of course, certain things that we can and we cannot seize. Things we cannot seize are, for instance, bedding, clothing, tools of the trade below the value of £1,350. If it is above the 1350 mark, then we can, of course, take control of those and with a view to remove them on. Things like perishable goods as well, we cannot seize those, although there are certain aspects where we can do it. However, there are certain legal processes that we have to go through. For instance, if taking control of them, we'd have to seek a further court order, but it's not something that's easily granted. We can't seize vehicles that belong to, for instance, a disabled person. We can't seize assistant dogs, etc. But ultimately, the rule of thumb is any goods and chattel, which could come part of it, any stocks, machinery, money or banknotes, livestock, jewellery, art, and so forth. And of course, there as well, that if you did want to have a further look at what we can and can't do, there is a link there for our ebook on that.
Lovely, thanks very much, Jonas. And we're going to have another quick recap and learning review for you in just a moment. And that first question is, how much is the court fee to transfer your claim up to the High Court? I'll give you another couple of minutes to answer that one. And so the correct answer for that question was, of course, £66 is the transfer up court fee. Next question, how much time does the notice of enforcement give the respondent to make payment in full? 7 days, 14 days, or 28 days? And the correct answer to that question was, of course, 7 days. An enforcement agent can force entry into a business or commercial premises. Is that true or false? And that is, of course, true, but only for commercial premises and only if they do not have residential premises attached to them, as Jonas mentioned in the case of the pub. And what percentage of interest can be charged per annum on award settlements? And the correct answer for that one is, of course, 8%. And our final poll question is just about to launch. So you should be seeing that on your screen. And the correct answer for that one is, of course, 28 days to return the ET3 form. I'd like to thank you all and our presenters today for doing this webinar for us. And there will be a survey, some survey questions that you'll be asked at the end of the webinar. It would be lovely if you could give some feedback to us. And I hope you enjoy the rest of your afternoon. Thank you very much.